breaking news. It's actually upcoming news that you're going to hear about on Tuesday. A major argument is taking place in Richmond, Virginia over whether or not so-called assault weapons, which are semi-automatic rifles, can be banned under the Second Amendment. Stay tuned, get the details when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. We really would appreciate your support. We're trying to get to 100,000 subscribers as fast as we can because it will make a huge difference for us when it comes to the algorithm and spreading the word of this channel. You guys tune into the Four Boxes Diner not just to hear what's happened and what really happened and to analyze and to understand from the Second Amendment context, the right to keep arms context, but I also try to tell you what's going to happen down the chessboard. That's why those of you who tuned in this channel many months before the Supreme Court issued NYSERDA versus Bruen, you basically knew generally what was going to happen with the Supreme Court, what I thought they were going to do and what they weren't going to do, and basically we got it right as to what the NYSERDA versus Bruen case said. Now, I'm going to do that again right here, right now. Major event this coming Tuesday morning in Richmond, Virginia. Richmond, Virginia, you see, is the home of the United States Court of Appeals for the Fourth Circuit. Now, the Fourth Circuit is one of the courts of appeals, one of the circuit courts around the United States. The states that are covered by the Fourth Circuit Court of Appeals include West Virginia, South Carolina, North Carolina, Maryland, and Virginia. Now, this case that's going to be argued before a three-judge panel in Richmond, Virginia, in the United States Courthouse there, is a case called Bianchi versus Maryland. And in the case of Bianchi versus Maryland, it is a challenge, a Second Amendment challenge, to the so-called assault weapon ban in Maryland. Now, this case was one of those cases that was up before the United States Supreme Court as NYSERDA versus Bruen was pending, waiting to whether or not a certiorari grant would come from the Supreme Court. But after NYSERDA versus Bruen was decided, the Supreme Court basically abrogated, which means to repeal or to get rid of, all of these decisions, all these lower court decisions all across America that had misapplied, in my view on purpose, but had misapplied the meaning and the scope of the Second Amendment and its protections. Well, this case of Bianchi versus Maryland was one of those cases. But Bianchi versus Maryland is very interesting, and I have high hopes for this one, because the three-judge panel that heard the Bianchi versus Maryland case originally and ruled against the Second Amendment 3-0 did so based on a precedent called Kolbe versus Hogan. Now, Kolbe versus Hogan was a 2017 case by the Fourth Circuit Court of Appeals. And you may ask, why do I care about Kolbe versus Hogan, Mark? Well, because the Fourth Circuit in 2017 misapplied the Second Amendment. And that's not my opinion. That's the Supreme Court's view and opinion. Why is that? You see, Kolbe versus Hogan was one of those cases that the United States Supreme Court, as part of its Bruen decision, sent back down and says, Kolbe versus Hogan? Wrongly decided. It is hereby abrogated by the U.S. Supreme Court. That's what the Supreme Court said in NYSERDA versus Bruen. It abrogated or got rid of Kolbe versus Hogan. The reason why that's very good news for our team is that Kolbe versus Hogan in 2017 held that bans on semi-automatic rifles did not implicate or violate the Second Amendment and upheld Maryland's ban on so-called assault weapons. Semi-automatic rifles, of course. Bianchi versus Maryland was a subsequent challenge that was brought against Maryland's assault weapon ban, against semi-automatic rifle ban. We know they're not assault weapons. That's a propaganda term by the left, by the anti-gun community. But the Bianchi versus Maryland case went before the three-judge panel. The three-judge panel said basically, look, we are bound, whether we like it or not, to the decision of Kolbe versus Hogan. That is binding precedent on the Fourth Circuit judges, including us. Therefore, we have no choice but to apply Kolbe versus Hogan that says semi-automatic rifles are not protected under the Second Amendment, and therefore we rule in favor of the gun control movement. We rule in favor of gun control and against the Second Amendment because we have no choice. Our hands are tied by the legal precedent of Kolbe versus Hogan. But in 2022, in June, the Supreme Court took Kolbe versus Hogan and tossed it into the trash heap of history which is exactly, in my view, where that should have gone, the trash heap of legal history. So what happens now? Well, now on Tuesday, a major argument will take place in front of 3 judges. And I think we know the judges. The reason why I say we think we know the judges, but we don't know officially, is because it's my understanding, based on the practice of the Fourth Circuit Court of Appeals, that you don't find out the name of the judges on your panel until either the morning of the argument or immediately before the argument or something like that, but it's very soon. So it's likely that no one's officially going to know the names of the 3 judges in the case of Bianchi versus Maryland until Tuesday morning, maybe Monday night. But we have a very good sense of who they're going to be. And why is that? Because historically in the Fourth Circuit Court of Appeals, the 3-judge panel that hears a case that is subsequently sent back down by the Supreme Court to be reheard is usually the exact same 3-judge panel. So who was the 3-judge panel that first heard Bianchi versus Maryland, the so-called assault weapon ban in Maryland, that ruled 3-0 against the gun rights plaintiffs in favor of the state of Maryland? And then it went up to the Supreme Court, and the Supreme Court sent it back down to be reheard. Well, the 3 judges, in my opinion, are very good for us. At least 2 of them are. So based upon my best guess as to who this panel is going to be, based on historical precedent, legal precedent of the Fourth Circuit Court of Appeals, the 3-judge panel is likely going to be Judge William Traxler, who was a judge appointed to the bench by Bill Clinton, Judge Julius Richardson, who was a 2018 appointee to the federal bench by President Trump, and a Barack Obama appointee to the federal bench, Stephanie Thacker. Now, based upon that 3-judge panel, I like our odds very much that the Maryland assault weapon ban, the semi-automatic rifle ban, will be struck down based on that panel under the Second Amendment. And why do I say this? Well, of those 3 judges, one of them, Stephanie Thacker, Judge Thacker, is likely terrible on this issue. She was participated in the Kolbe decision I mentioned earlier, but she was in the majority opinion that says that the Second Amendment does not protect semi-automatic rifles in the United States, which I think is an absurd conclusion for a whole list of reasons we can get into down the road. But the bottom line is, I don't think that Judge Thacker is going to be particularly friendly to gun rights. But if she follows the NYSERPA versus Bruin decision, we should be in good shape even with her. But I have my doubts because of her track record, which is, in my view, anti-Second Amendment. Basically, there is no Second Amendment as best I can tell from her point of view. But the other 2 judges I have high hopes for. One is Judge Richardson. He's, again, a President Trump appointee. He has already issued 2 decisions. One saying that 18 to 20-year-olds have a Second Amendment right to be able to buy handguns from FFLs, saying that federal law violates federal law that says 18 to 20-year-olds cannot buy guns through FFLs. Judge Richardson said that violates the Second Amendment. So he seems like he's pretty good on the issue of the Second Amendment. He also dissented in the case involving a federal ban of having possession of firearms if you have a domestic-related violence misdemeanor conviction. He dissented, saying that, basically, I think he concluded that, these people are not dangerous. This is a misdemeanor conviction. You can't lose a fundamental Second Amendment right for your entire life based on a misdemeanor conviction. That's absurd. And Judge Richardson dissented in that, saying that, I think this violates the Second Amendment. So I think Judge Richardson, at least his mindset, it should be sympathetic to the approach of NYSERPA versus Bruin. So I think he hopefully will be good. Judge Thacker, again, will be bad. I suspect Judge Richardson should be good, I'm guessing. And then that gets to the 3rd judge, Judge Traxler, who is a Clinton appointee. But what's interesting is Judge Traxler wrote a very powerful dissent in the Kolbe versus Hogan case. Remember, the Kolbe versus Hogan case was the decision that said in the Fourth Circuit that semi-automatic rifles are not protected arms under the Second Amendment. An absurd ruling, in my opinion, but set that issue aside. Judge Traxler disagreed with the ruling. He says that obviously semi-automatic rifles are protected arms under the Second Amendment, and that the so-called assault weapon ban in Maryland should be struck down as unconstitutional under the Second Amendment. So on Tuesday, we have a 3-judge panel, Judge Traxler, Judge Richardson, and Judge Thacker. 2 of the 3 are already on the record strongly in favor of a robust interpretation of the individual right of the Second Amendment to keep and bear arms. 1 is against that on the record. So if that's the 3-judge panel, which I anticipate it will be, because that was a 3-judge panel that decided Bianchi versus Maryland before it went to the Supreme Court, and now the Supreme Court has sent it back to the Fourth Circuit. And again, historically in the Fourth Circuit, the panel that heard the case before the Supreme Court sent it back is also the same panel of judges that hear it after the Supreme Court sends it back. So that's my best guess, and that's good news for us. Now, again, I also want to, since we're talking about assault weapon bans, remember the basic standard is really quite simple. If a firearm is commonly possessed by Americans for lawful purposes, it's protected. This should be a very easy case. We know in many cases it says that. 2016, the Caetano versus Massachusetts case that said that commonly owned, commonly possessed arms are protected under the Second Amendment. And in that case, it was stun guns, of which there was only 200,000 of them in existence in civilian hands in 2016. We know that semi-automatic rifles are owned by 20 to 40 million people in the United States, depending on what data you look at. But either way, it's tens of millions of people. That's more than enough to meet the common use test under Caetano, under Bruin, under Heller. So really, this should be a very easy case in the so-called assault weapon ban or semi-automatic rifle ban in Maryland. So Tuesday's a big day. We're going to have oral argument in the Fourth Circuit in Richmond, Virginia. It should be very interesting. We'll see who the judges are. We'll see how the arguments go. I will try to put a link to, I think there's actually a link available either to the audio or video. I'll see if I can figure that out and put it to a link to this video if anybody wants to follow it. But on Tuesday morning, there'll be a big argument in the Fourth Circuit Court of Appeals involving the Second Amendment. And after that argument, I'm guessing there probably will be a decision written by that panel at some point in the next couple months. So we will find out what happens probably in January is my best guess, although one doesn't control the courts. They can do anything they want. But that's my best guess. It'll be, 4 to 8 weeks out. But we'll see what happens. Okay, I hope you learned a little bit something about Bianchi versus Maryland, the oral argument coming up. If you haven't subscribed to the Four Boxes Diner, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.